Chief Justice John Roberts may want to ask himself, how many insurrectionist flags are too many for one of his justices to fly? His colleague, Justice Samuel Alito, seems to think that flying insurrectionist flags are okay as long as you can blame it on your wife. Ironically, it may be the only space in Alito's America where a woman's autonomy is recognized and respected. He is, after all, the author of the opinion that overturned Roe v. Wade. The public revelation of the flags flying over Alito's residences, flags that were also carried by January 6th rioters, prompted calls for Alito's recusal from 2 January 6th cases. Dubbed Flaggate, this is just the latest ethics scandal to rock a court facing a crisis of legitimacy amid an historic loss of public faith. The nation's highest court, long revered for quietly steering jurisprudence toward stability, increasingly resembles a messy reality show. But it's probably not all that surprising that our institutions, with MAGA extremists among their ranks, are beginning to mirror the chaotic world of Donald Trump, the twice impeached and now convicted former Apprentice host. Flaggate follows a string of ethics controversies, calling into question the court's impartiality, including revelations that Justices Clarence Thomas and Samuel Alito accepted lavish gifts from GOP mega donors with business before the court. The justices appear to be doing right by their conservative donors, refusing to recuse themselves from impacted cases while presiding over landmark rulings that have chipped away at the civil rights of millions of Americans. From overturning Roe v. Wade and gutting the Voting Rights Act to chopping down the Environmental Protection Agency's power to fight climate change, the court has loudly and unapologetically declared war on judicial restraint and on its own tradition of stare decisis, the principle of the court following its own long-established precedent. All of this raises questions about the Chief Justice Roberts, his role, and whether or not he has lost control over his court. Roberts has so far refused to meet with members of the Senate Judiciary Committee to address the court's unprecedented ethics crisis, insisting that the court will continue to police itself, or at least pretend to. On Tuesday, the Senate Majority Leader Chuck Schumer criticized Roberts, stating, quote, "Justice Roberts has, in my opinion, not lived up to his responsibility as Chief Justice on issue after issue," end quote. Recent remarks from some of the sitting justices have only served to underscore just how chaotic and unaccountable this court has become under Roberts. Speaking at Harvard University, Justice Sonia Sotomayor revealed, quote, "There are days that I have come to my office after an announcement of a case and closed my door and cried. There have been those days, and there are likely to be more. There are moments when I'm deeply, deeply sad. And there are moments when, yes, even I feel desperation." That is a sitting justice experience of the highest bench. It is marked by desperation. This is telling, to say the least. So how many insurrectionist flags would be one too many for a Supreme Court justice to fly? Justice Roberts believes that's not a concern for the American public. For more on this, I'm joined by Melissa Murray. She's a professor of law at New York University and MSNBC legal analyst and co-host of the Strict Scrutiny podcast. Good morning, Melissa. Thank you for joining us. Some people argue that Chief Justice Roberts might go down as one of, if not the worst Chief Justice in history, with some legal scholars like Steve Vladeck even calling for his resignation. Tell me if you think these criticisms are fair, the criticisms of Robert as distinct from the criticisms of some of the things that members of the court are doing.
So this is a really interesting question. I mean, there are some great contenders for worst Chief Justice, chief among them, Roger Taney, who wrote the infamous Dred Scott opinion. But this Chief Justice, I think, is going to go down in history as perhaps being the least capable administrator. And that's something interesting because he actually started out being quite a capable administrator. I mean, I think it's really important to separate what it means to be a justice of the court and what it means to be the Chief Justice of the United States. John Roberts is not just a member of the court. He's the chief administrator of the federal judiciary. So all of these questions about recusal, about judicial ethics, this is right in his wheelhouse. And his refusal to do anything about this court and about the lower federal courts, where there have also been questions about recusals and acts of impropriety, like participating in cases in which justices or judges have an interest, a financial interest, those have abounded in the last couple of years. And he's done precious little. What he has done is really resisted calls from Congress to step in and regulate by writing statutes that might call these courts to account.
So this is an interesting point. He's the chief administrator of the federal judiciary, which suggests a different role than maybe most of us are used to thinking about the chief justice. He did say justices will police themselves, so that's paraphrasing. How much control does he actually have over the conduct of justices, for instance, the flying of these flags that might be insurrectionist? Is it a matter of he can set sort of ethics rules, or can he actually go to Alito and say, you're causing problems?
Well, he can always go to an individual justice, but I think the real issue here is when John Roberts lost control completely was when this court became a 6-3 conservative supermajority. There was a period in time after 2018 when Justice Kennedy stepped down from the court where John Roberts was the absolute center, the fulcrum around which this court pivoted. There was only 4 really conservative justices on the bench, and he was the 5th vote if they wanted to have a conservative majority on any case. And sometimes he went with the liberals, often for institutional concerns. Now, with a 6-3 conservative supermajority, there is always a 5-person staunch conservative majority, and John Roberts isn't needed. And I think that trickles in not only in the substance of the decisions, but in the way this court is run.
Steve Vladeck has written, it's not the Roberts court anymore, and it hasn't been since the day Justice Ginsburg died. And the reality is that probably by this time in July, you're going to see a lot of pieces about how this is Amy Coney Barrett's court, how Barrett is going to be the real decisive vote in the cases that matter. Speaks a little bit to what you were just saying. Tell me, interpret that for me.
So it means the court is shifting. With a conservative supermajority, again, Chief Justice Roberts isn't needed at all. And so the real fulcrum of the court now turns around those Trump justices, particularly Amy Coney Barrett and Brett Kavanaugh, who are often in the center. And to call them the center of the court isn't to say they are moderate or centrist, but that the court has moved so far to the right because of the shift in personnel and the addition of a 6th conservative justice that the Chief Justice is really out in the wind, out in the wilderness. And we're seeing that not only in big decisions like Dobbs, where the Chief Justice tried valiantly to steer a middle course and didn't have the votes to do it. The 5 conservatives were like, no, we're overruling Roe. We don't care what you say. And they basically said that in the opinion. So he's kind of out in the wilderness, and he's really lost the thread with this court. It was really interesting last week when Justice Alito responded to Senators Durbin and Whitehouse. He was responding to a letter that had been sent to the Chief Justice, and he responded before the Chief Justice did. And that was sort of an indication that we don't listen to this guy, and you shouldn't either.
So what can be done about this? I mean, you and I have had this conversation, and you are so brilliant, but I would like a remarkably satisfying answer on this one, and I'm not sure that you have one to provide. What can we actually do to restore our trust in the Supreme Court and feel that it is a body that operates fairly, and if it is going to police itself, at least polices itself well?
Well, Congress can definitely do things. I think right now in an election year, there are many who are in the majority in the Senate who worry that their slim majority makes it impossible for them to actually do anything right now. But I think individuals who are running need to run on this court, need to run on the fact that this is a court that's chaotic and out of control. And more importantly, voters need to understand that impeachment was always a way to check the judiciary. Congress can impeach federal judges. They can convict federal judges on impeachment charges and remove them from office. And they have in the past. It's just that in the last 5 years, we've really seen that where we have slim majorities in the Senate, impeachment is really a paper tiger. And that trickles over. If the Chief Justice could point to Congress and say, you could be impeached, Sam Alito, for doing this, I think he would have a lot more purchase with his colleagues, certainly with Sam Alito. But the fact of our polarization, the fact that there isn't a clear majority in the Senate makes it a lot harder for the Congress to control this court and for the court to control itself.
So you made reference to things that Congress can do. The Supreme Court Ethics Recusal and Transparency Act, which is the bill that was proposed by Senators Durbin and Whitehouse. It aims to establish a code of conduct. I don't know if you had a chance to sort of thoroughly consider this, but what do you make of this proposed legislation?
Well, I think one thing that's really interesting here is that it provides for a counsel who would be available, an ethics counsel who would be available to vet ethics questions before the justices. Famously, Justice Thomas said that he consulted his colleagues to find out if it was okay to not disclose private jet travel or hotel stays that billionaires provided to him. If we had an ethics counsel, there would be no need to sort of crowdsource this kind of question, but you could actually go to one person who could provide a consistent and coherent answer to all of the justices, and there could be some uniformity. And if those disclosure recommendations weren't followed, there could also be accountability. I mean, those are basic things. I mean, these proposed statutes are not upending the cart. I mean, they're really tinkering at the edges, but the fact that those kinds of tinkering could really change things shows how off the rails all of this is already.
Yes. At the moment, I would take some tinkering. Melissa, great to see you as always. Thank you, my friend. Melissa Murray is a professor of law at NYU. She's an MSNBC legal analyst, and she's the co-author of the book, The Trump Indictments, the historic charging documents with commentary.